What's up, everybody? It's Stephen Williams, founder and president of the creditrepairshop.com. We have a summons complaint here. We're going to review it. We cannot do this enough because it's just like getting practice. If you ever receive one, you want to know what to do without panicking. This is one that a YouTube viewer just sent over to me, and I'm going to explain what they can do about it. And if they wanted to hire us to rewrite it or to do the response for them, we have a fee that we charge for that, but you can do this on your own, and I'm going to show you exactly how to do it. First thing I want you to do is to like the video, because you know that I'm giving you information that other people or credit repair companies don't even get into, because they're just about sending out letters. But please like the video. It helps other people that need information to find us. And it involves you in this community also, because you're helping people that need help. So this is from this company here. I'm not going to mention it so we won't get the video flagged. And this is the amount, $7,425.68. This is just basically giving information about the company that is trying to come after this individual for the debt. When you're doing the answers, what you're going to do is you just go, first you just need to read these. These are the allegations that they're having. It's not like it's something huge. This is civil court, but they're, just making their statements here. This section here is just stating that it's a contract. And this statement here, this civil code, is that they've sworn that everything in this summons is true, which we don't know that yet, and I'm going to show you exactly how to find out if it's not true. But so first, what we're going to do is we're going to prepare our answers to this summons. So let's go back up here. Let's go back up. Okay, so now, we're doing the answers, and I'll go back here. So for this one here, we're going to start here. They're saying that, talking about the plaintiff and, laws of the state of Delaware, and is qualified to do business in the state of California. You could just put, you don't dispute that. Defendant is a natural person. Of course, you're a natural person. I've seen this stuff is done weird. It just depends on who's putting it together. Usually they'll put the individual's name there and say that they reside at such and such address. I believe that they did not do that because they were not able to serve this individual, so they just put this there. And then they just put that the defendant resides in the jurisdictional district. Therefore, jurisdiction and venue are proper in this court, because you can't serve someone that doesn't live in that area. Like, you can't say you're going to serve someone in New York and they live in California. You'd have to get an attorney and go to the court in that area where they reside. But you would just put right here with an answer to number 3, and you put number 1, don't dispute. Number 2, yes, you are a natural person. Number 3, yes, you reside in the area. You don't even need to go and put an address on there. And then here's the claims right here. Right here, this is that you could just say you just don't dispute number 4. That, okay, there's a potential contract, but there's no dispute at this time. Now, let's move over to right here. Number 5. Here we go. This is where all the fun starts. Okay, that at all times material defendant has been the obligator of a certain credit card account bearing number, and then this is the account. The defendant agrees by the use of said credit card to assume responsibilities for all credit extended on the basis of said accounts. Blah, blah, blah. It has this information on here. You could just put that you do not dispute that. Because the reason why I say you don't want to dispute it is because this section, number 5, is because, you don't know what it's about. You had the card. So if you try to set this up in a way to where you're trying to say, this account is not mine, that's not going to work. What you need to do is right here, just say you don't dispute. Now, let's get to number 6. With the amount, that, just like in my last video, this is where you start to do the validation of this amount. Just because they say this is the amount does not mean that this is the amount. So you need to do a dispute or a validation of the debt. And what you do is you send that validation to the court and you send it to the debt collector. But now let's hold on one second. I'm going to get you a list so you'll know exactly what to ask them of. Hold on one second. Okay, I wanted to make sure I got the email, because if you're the individual that sent me the email for this, I'm also responding to you by email. It's going to have step by step what you need to do. So right here for number 6, this is where you would dispute, where you would do a validation. Sometimes they will say that you did not dispute the amount. So what we're going to do right here, number 6, is you're going to say that you do, number 1, you want them to prove everything about this debt, but also you want to take it a step further to ask if this debt has been sold to a collector, to them, the attorney that's trying to collect it now, or are they contracted by the credit card company. You want to know that relationship, because that's going to take you into different avenues on what they may and may not have on proving the debt. So now what you want to do is you want to, for number 6, you want to say that you would like to dispute the amount that they're claiming that you owe, and that you would want them to give you copies of the original contract with the original creditor. If they are still owning the debt, then it's going to be from them, but they'll let you know when you do this validation. They'll let you know if they've purchased it or if they're collecting it for the original creditor. Now real quick before I move forward, you can trap them right there, and we've had clients do this in court where they didn't even show up, is if they say that they're collecting it for this credit card company, and I can tell you that this credit card company does not usually sell their debt. They do usually hire companies, lawyers, debt collection companies to go after people for the debt. I can tell you that they're one of the ones that will keep the debt and not sell it. Okay, so with this one, what you want to do, and let me bring my email back up. So you want to ask for the original contract. You want to get all of the charges with your signature to substantiate the balance. You want, if it's an internet charge, you want to have time stamps for that. If it's a charge at a store or something, you want to have your signatures proven, or if it was a debit card or debited type transaction, you want to have proof of that. You want to get that's for all of the charges that they claim for the balances. Then you also want to get the interest rate disclosures, because they have to disclose the interest rate on every statement. So basically what you're making them do is to send you every statement for every charge that you've made, with the balances and the payments that you've made also. So you want to get the payments that you've made on the card so you can reconcile that against what they claim you also owe. And then you want to get the payoff balance disclosures, because with every credit card statement, they must tell you by law, if you pay a certain payment, how long it would take you to get it paid off. Now, I admit that some of those things that we're talking about on there are, some technical things that if they're not able to prove them, that's what can get this whole thing thrown out, because they're not proving the debt. Doing it this way is a lot better than trying to go into court and say this debt is just not mine, because that's just not going to work. Now, before we move forward again, we always want to make sure that the debt is not past statute of limitations. You can do that by looking it up for your state and seeing if for contract law if it's past statute of limitations. Now, to be able to prove if it's past statute of limitations, you're going to need copies of your credit reports. If you don't have those copies, you can go to the website, the number 3scores.com, and you can look and see when the original charge off or write off date for that card was, because that's going to be very important, because it could potentially be past the statute of limitations for collecting the debt. And you won't know that unless you go there and look. Just because they say it's collectible does not mean that it's collectible. The other thing is that you want to get your credit reports, because in the comments section, you never know. And we've just had a slew of these come through from clients where the credit card companies, and this was one of the companies on a previous video, that back in July or June, they actually canceled the debt and sent the 1099-C to one of my clients. That means that they cannot collect the debt. Once they do that, they cannot sell it or have it collected. It's 100% forgiven, and it's considered canceled by law, and this amount would go as income to the individual that they wrote, that they canceled the debt for. So pay attention. But the only way you're going to be able to find it out is two ways. Number one is you would look on your credit reports and see if it showed that it was canceled on there. The other way is you can actually contact the company and ask them, did they cancel the debt? And then you can see what would happen after that. Now, number 7, plaintiff realleges and incorporates herein the allegations set forth above, which is everything above. You can just put NA, or but just put NA right there, because you don't want to give them any upper hand on anything. Let's see here. Let me get this screen a little bit smaller. Hold on one second. I need to pause the video for a second. All right, the next thing here, we got defendant became indebted to the plaintiff within the last 4 years on an open book account for money due. You double check that. This is one where you can double check your credit reports and see if that's true. Number 9, if it is true, then you can just put don't dispute. But you're disputing the amount. Again, you're disputing the amount. Plaintiff, number 9, plaintiff kept an account of debts and credits involved in the transaction. You can just put don't dispute. Defendant owes plaintiff the sum of, they're trying to sneak that in again. Right here, you can say, you can repeat what you put right here for number 6. You can state that you either repeat what you put here, or you can state to refer to your answer of number 6. Let's see here. Let's go down number 11. Defendant became indebted to the plaintiff within 4 years. This is just reiterating what they had up there. Sometimes I think that they just try to trick people up, because sometimes you never know what type of judge you get in front of. If you don't answer all of these or put some type of statement back on each of those, you can actually, some judges can actually say you did not properly answer every question in the summons. Defendant by words of conduct agreed that the amount stated, see right here, by words of conduct and owed to the plaintiff and promised to pay the stated amount. Right here again, see, they're just trying to slip the person up. You would repeat what you had for number 6 and number 10. Repeat that you are requesting verification of that amount. That's what you want, verification of that amount. So now let's go to the next page here. Number 13, defendant has not paid any or all of the amount owed under this, what you would just put here is that you want verification of the amounts, that you're not, you're not going to let this statement stand. And then again, they're saying it all over again, and you would put the same thing that you had in the other ones there above with number 610 and what was it? 610 and let's see, number 12. 610, 12 would all be the same. All right, this is just for what they're asking for, so you don't need to worry about this part here. This is just what they're asking the judge to do. And let's go to next page. We just did one in California not too long ago, and it was a lot longer than this one. So I guess it just depends on where you're at. I thought that they should be the same. I need to blur this out right here. But this is where you would send it. So you would just send it to here. And you would also send it to here where the attorney's name is, because that's the plaintiff attorney. And then you would also send it to the court, to the judge, to whose courtroom the answers need to go to them also. So I hope that everyone got more instruction out of this. If you don't find yourself in this situation right now, it's still good to understand it, because you never know if this could happen with someone purchased an old debt or something from that you might have owed in the past. Please like this video. Please share it. Please comment. Please subscribe to my channel. This is real deal information. If you need help, go to my website, thecreditrepairshop.com. If you need your credit reports and scores, remember everything starts there. Your number 3 scores.com. I'm putting everything on the screen here so you can see it. And until next time, this is Stephen Williams, founder and president of thecreditrepairshop.com. And I will put this disclosure that all information here in this video is for information purposes only. If you need legal advice, please consult legal counsel in your area. Thank you.